With regards to the shareholders' remedies against oppression, we refer to Section 346 Companies Act 2016, which provides that the remedy for a member in the event of the affairs of the company are conducted in a manner which is oppressive, in disregard of his interests as a member, discriminatory or prejudicial to him. So, when we interpret the Section 346, however, there is no definition under Companies Act for the word of oppression in disregard of his interests, unfairly discriminate or prejudicial. This can be referred to the case of Recon Thai Sawmill, Miri Senyang Berhad. And also, the complaint must continue to the rights of the date of commencement of the action is supported under the case of Owen Siang Yang Ku. So, the grounds of the complaint, there are four. First one is the expropriation of the corporate asset. Second one is damage of the profit. Third is disregard of the minority rights. And the fourth one is the depriving of information. So the remedies provided is stated under Section 346 subsection 2, whereby the court may make an order in terms of although Section 346 subsection 2 was silent, the court may order damage to be paid for the oppressed member to be supported in the Ko Zui Hyung and Gi Tak San case. So actually this sum up the shareholders' remedies against oppression.
Next, we continue with the differences between Section 181 of Companies Act 1965 and Section 346 of Companies Act 2016. So here is the provision regarding the Section 181, and in this section, we can see that it provides statutory relief for an aggrieved member of the company in case of oppression. And in this case, an aggrieved member may succeed if he or she can establish that, firstly, the company's affairs are being conducted or the powers of the directors are being exercised in an oppressive manner or in disregard of the members' interests, or some unfairly discriminatory or prejudicial Company Act has been passed or threatened, or prejudicial resolution has been passed or is proposed to be passed by the members, debenture holders, or any class thereof, if the resolution or Act was introduced to protect the position of minority shareholders in limited companies. So that in this Section 181, prior to the rules of Court 2012, proceedings under Section 181 of this Act were filed by way of petitions. Majority of cases will be referred as an oppressive petition. The rules now prescribe for the filing of an originating summons instead. Now, the cases will be referred as oppressive actions. Next, we move to Section 346 of Companies Act 2016.
So now we move on to the legal issue regarding the oppression. So here there are three main issues here. So regarding the first issue is there is no definite guideline as to what amounts to oppression. There are no statutory definition of the term oppression in the Act. Subsequently, Malaysian cases have referred to common law guidance resulting in various interpretations. So in the case of Ray Harmer, oppression was defined to include burdensome, harsh and wrongful. So now we move on to the next legal issue. There is also no definite test to determine what constitutes oppression under Section 181, and the court must look at the alleged acts of oppression as whole and not in isolation. Question as to whether there was oppression must be determined based on the facts of each particular case. So move on to the last legal issues here, the parties' locus standi. Section 181 itself lists those who are entitled to invoke it in seeking appropriate relief from oppression in the courts. So the section begins with the term member or debenture holder. So this would mean that a member or debenture holder may also obtain a remedy if the conduct complained of is contrary to the interest of one or member of the debenture holders. However, there is no definition in the Act for both terms, both member and debenture holder. So thus, the section provides relief to shareholders and creditors.
Now we move on to the cases on the oppression remedy for minority shareholder.
Shares allow voting rights, but if you are not a majority or substantial shareholder, then there is every chance that you may be outvoted on a matter that may be crucial to you. What if you feel what the directors or majority shareholder are doing is wrong? Can you take an action? The general answer is no. There is a rule called the false and hard water. However, under Section 181 of Company Act 1965 and Section 346 of Company Act 2016, it gives a remedy in cases of operation. But a person who joins a company as a member of shareholder must bear in mind that she or he does so on the understanding that she or he may be outvoted. This is called the majority rule, which simply means the will of the majority should prevail, just like democracy. You therefore may not challenge the decisions of the majority just because you do not like it. There must be oppression. This was explained in case of recompiled sawmill Miri Cinderella in 1978. So cases that succeed under claim of oppression is as follows. Next, we proceed to the cases that fail to claim under oppression, and the cases are as follows. Now we proceed to the latest changes under the new Company Act.